Hi everyone, very good evening. A very warm welcome on behalf of whole LeDroit India team. My name is Ria Chabra and I'll be your host for the evening. So before starting with the session, let me just brief you out about few details. Okay. Can I just know how many of you are joining this session, like LeDroit session for the first time? Kindly raise your hand, like whoever are joining the session for the first time, interacting with LeDroit for the first time. Okay, there are many people who are interacting with LeDroit for the first time. Great. So, do let us know from where you learned about this particular webinar, whether it was LinkedIn, Instagram, or whichever platform. Okay. So, do let us know. And also, we'll be asking you questions like from where you are joining, but that will be later on. For now, just let me know like from where you learned about this particular webinar. Great. So, most of you have learned about it from LinkedIn. Okay, great. All right. So, to begin with, LeDroit is an online legal edtech platform. We aim at providing practical legal education to bridge up the gap between law school and real practical world. Our courses are completely practical in nature, and we have been conducting courses of like in both the pattern self-paced as well as in live sessions. Okay, and we also provide certain workshops, webinars. We also provide certain free training. We provide you CV guidances as well. So if you have joined the WhatsApp group of the webinar or Ledroid's group, kindly stay connected with us because every now and then we conduct such workshops where we pick up any particular topic to train young law students. Okay, so stay connected over there. Apart from that, if you are very much eager to learn, then we also go live every Friday at 6 p.m. on our YouTube channel where we discuss about different contracts used in different industries. Based on industries, we discuss about various contracts, so that will be a very much helpful for you if you are eager to learn about the practical scenarios. Okay, so you can subscribe our YouTube channel for the same. So yes, now coming on to today's webinar. So we all know that today's webinar topic is how to start with legal drafting, step by step process. The particular workshop will be conducted by Advocate Aditya Rana. He is Delhi High Court and Supreme Court advocate with 10 plus years of experience. And the main purpose of this webinar is to explain you, like properly guide you on how to start with legal drafting, what's the importance of legal drafting, and he is going to share his practical experiences with you today. Okay, so we have restricted the entry to this particular webinar till 7:45. So make sure that you are not leaving the call because after that you won't be able to rejoin the session. And towards the end of the session, we will be sharing a feedback form in here on the chat itself, to which you have to fill up in order to receive your certificate. The link for that workshop will not be shared on the WhatsApp group. So make sure that you fill that up and then only leave the session. Okay, it will be shared towards the end, so kindly stay throughout the session because you cannot rejoin it after a certain time. All right, so that's all. Now some of you are also attending this session as a demo session, so towards the end we'll also be explaining you about the course, but that will be towards the end of the session, not right now. Okay, thank you Abdul for sharing the YouTube link of Ledroid. Thank you so much. Yeah, so make sure that you are there in the session throughout the end. Yes, this particular workshop is free and you will be receiving certificate of participation towards the end. So don't leave the session because you have to fill that form and then only drop the call. Okay, we will notify you like we have shared the form in the chat. All right, so that's all. Can I have your thumbs up that you guys understood everything? Is there anyone who haven't joined the workshop group? Because once the certificates are shared, we are going to update you in the group that we have shared the certificate for this particular workshop. Also, like today is Monday, so you can expect to receive your certificates by next Monday or Tuesday. It takes around 1 week to share your certificates. Okay, let me just share the group link for people who haven't received it. 1 second, I'll just reshare it for the people who have directly joined the webinar. Okay, so those who are not there in the workshop group, you can join through the link. I've shared the link. No, this particular session is not about internships. It's about how to start with legal drafting. Okay, so we are discussing that. All right. So that's all from my end. Let me just check whether sir has joined the session or not. Yes, you will be receiving recording of this session as well. So you'll be receiving the recording as well as the certificate. No, Harsha, this is not IPR session. This is with regard to legal drafting. Okay, let me just check with sir. Also, one more thing, that all our LeDroit webinars and classes are very much interactive in nature. We allow our students to engage with the faculty, and you can feel free to ask all your queries during the session. Okay, so but right now, considering the number of people, we haven't allowed you to unmute yourself, but we will be giving you that right as well. So please make sure that you are not misusing it, otherwise you will be blocked from everywhere to join LeDroit session. Okay, so just make sure that you are not misusing that thing. You can unmute yourself, you can raise your hand if you have any questions to ask, to ask to faculty. And yeah, that's all. So let me just see with the faculty, 1 second. Sir, can you just try to unmute yourself?
Good evening, everyone. Am I audible?
Yes, sir, you're audible. And others as well, like you can unmute yourself by raising your hand if you have any questions. Okay, so yeah, over to you, sir.
So, without much now to discuss about other things, let's just start straight away with the session. Now, I just want to know what you perceive about the coursework. Why you have, you know, uh, come up to this place for what purpose? What is your basic difficulty that you are facing while drafting? Just forget about legal side drafting or basics about drafting anything. Just let me know what are the basic things that you face day to day, for which you need some clarity or for which you need some practical experience over here.
Terminology as well as sometimes
Yes, framing facts. Mostly, if I categorize it, it goes with we have all the facts, but we don't know how to project it. Is it so? If I say in a simple terms that now we know this is the cause of action, this is the issue which is to be started. Let's just say that I know that I have to send a legal notice, but I even know the facts of the case. Then the confusion starts. Where from should we start? Where should we end? Where should we make more emphasis? What should be projected in totality and what should be just informed and let move further? यही होता है. Audible with. First thing is collection of facts. That's the main difficulty. Client comes, gives you an interview. You ask him every question, that what, how, when it started, all those things, all historic things and everything you have sorted out. Now he gives you 100 facts. In those 100 facts, now complexity starts, which is to be used, which is to be thrown out. Chalo. First purpose of drafting. Why a draft is used? What is the purpose of drafting? The purpose is whenever you are not available, whenever that person is not available, their case should be understood as verbatim. Every time a person has filed a case, every time his storyline cannot be heard by him, we want it to be crystallized somewhere. Not help proxy counsel, but it's matter of record. Now, whatever you have stated, it should be stated in totality. It should not be that tomorrow I will change something else, I'll do ads, I'll add, I'll subtract something. So whatever has to be said at a specific place at a specific time. so that even when you are not available, your draft, your plaint, your written document can speak for yourself. That means each and every fact has to be dealt in that way. Now, the problem is how to write. The basic problem which everybody faces in starting. I personally felt the same, but how I countered it was we all make notes. We all make notes. We all have those sticky notes for our sake of assistance, or we try to write down somewhere. If a senior is saying something, he is narrating us something, we quickly try to record it somewhere, write it down somewhere. Why? For offline review. Similarly, when you start drafting, first thing is collection of facts. The basic thing, if facts are clear to you, half of your work is done. Okay? Now, collection of facts cannot be from left, right, center. It has to be in a synchronized manner. Why? When I say facts are to be collected in a systematic manner, there is a reason. I'll connect it with your practical examples from your day-to-day life, and then you can understand better. You all watch movies. That's the very common thing everybody has in now. If you have recently watched some movie and I ask you about the storyline, that kindly narrate me about that. Will you start from the end? Because human brain is, when you create a visual from past, then you can connect it to the present. So you start from the beginning. But do you narrate each and every frame? Only that relevant one. Because time is essence. If you keep on narrating the whole story, which is revolving in 3 hours, anybody will leave the conversation. So it has to be kept in fit time frame. Now, facts narrated in a systematic manner, keeping the relevancy of facts in knowledge. For example, in our legal side drafting, what we consider is minimum there are two parties to a dispute. Okay? One is the aggrieved, one is from which the person is aggrieved. Okay? So when we start our plaint or when we start drafting, first we try to establish their relationship, how they came in contact. Can we start without connecting them? How they came at a common point? For that, we have to give some backdrop. So when we connect that backdrop with the transaction which they were dealing, and after that transaction, what breach occurred in there, then we come to straight away cause of action. So when we are collecting facts, first thing that is to be made in your clear mind is never ever think I will just note down the important facts. Each and every fact in the first client interview at the first prime FSI is important. Okay? Now, we may omit some facts from this session only. If I say 100 things, you will retain only 80. Tomorrow it can go to 60. There's a 10% loss or 10% deletion theory. That if I said 100 things, you will only, sorry, you want to ask something? So for that, any query? Anyone has a query? You can just raise your hand if there's so. Should we continue?
Good evening, sir.
Good evening. Yes, is there any query which
Sorry.
is to be sought right now?
Yes, sir. Yeah, I have a
Yes.
question, sir. My name is Suryansh and
Yes,
I'm
please.
pursuing my graduation, sir. And my question is
Yes,
that right now on present time, sir, in such cases जो रेपिस्ट होते हैं वो ज्यादातर बेल में क्यों छूट जाते हैं रिसेंट में?
I couldn't get your question. Can you just repeat it in a very concise manner?
Yes, sir. I want to say that there, if in a rape case, the rapist had the let off the on bail. I mean that the rapist जो होते हैं वो basically bail पे छूट जाते हैं. ऐसा क्यों? क्योंकि
Okay.
हमारे कंट्री में जो रेपिस्ट है सर वो आजकल मतलब केसेस बहुत ज्यादा बढ़ रहे हैं. चाहे वो
You
निर्भया
have
कांड हो चाहे
you, okay,
चाहे वो
I got
डॉक्टर.
you. I have got you this question right now, but see, we are right now on drafting session. I'll take this question at the end, but till that time, I'll just say something to you. We have a concept of innocent till proven guilty.
हम्म.
And when this concept of innocent till proven guilty is there, till the time conviction is not finalized over that particular alleged accused or that accused person, his personal liberty, which is governed by Article 21 of Constitution,
यस सर.
prevails. That is why bail is only a conditional relief which is given. They are not let free in the open society. So, to that extent, just hold on for a second. If we keep on saying that everybody, if we look with a single angle that every accused is convict, every accused is offender, then we cannot do justice to those cases. Okay. Now, coming back to our session. Now, first thing is we are deviating. We are here for first drafting session. Bail and everything there will follow subsequently. Right now is how we should attempt our drafts. Drafting is a simple skill to communicate your case effectively. Okay? If you cannot communicate in your drafting, then half of your case is already gone. Why? Because at the argument stage, you can make oral submissions. But when the file goes back into the chamber of the honorable judges, they read it again. And that time, it might happen that your oral arguments, they might have been skipped somewhere. They might not be observed in your written plaints. So it is always advisable that you take all your probable defenses in your pleadings, so that whenever it is open, that that paper book is opened, whenever that draft is read by any person, he gets the exact value of that particular content of your draft. That what exactly you want to say, what is your defense, what is your supporting evidence, what exactly is your argument. So now, first and foremost is the first stage. Drafting is only in three phases, if I precisely say. First is collection of facts. Second is research. Third is finding cause of action. Okay? If you have facts, you don't know the law. Can you draft? Yes. If you have facts, you don't know the law. You have facts that now a person is from a Hindu undivided family. There's a property also. Now that person seeks some partition in that property, he wants a share. But you don't know about the Succession Act, Hindu Succession Act. You don't know about Transfer Property Act. Can you draft? You can at best draft a simple list of date and events. Now, follow this practice. It it's not nothing. It's not new. It's not some proven something. It's just what I have started doing. I felt that it should be communicated to everyone. Screen is visible to all of you.
Yes, sir.
Screen is okay. Now we were drafting a civil case over here. Now what happened is this civil case pertains to the first thing that occurred was for the year 1979 when the first issue started. Now 79, we are filing in 2025. Now, can I, in simpliciter 2 or 3 paras, narrate my whole case? If I tell you the whole case in 2 paras, will you be able to understand it? So for that, follow this particular thing. I'll tell you why and from where I followed this. Whenever you are in your stage of preliminary interview or preliminary discussions with your clients or the person litigant who is approaching you on any of the sides, petitioner or respondent, whatever, make a table that is date, event, and annexure. Why? Because whenever you draft something, second thing comes burden of proof. In law, there's a concept of burden of proof. If I'm alleging something, burden of proof is on me to prove my allegations. Okay? So for that, who will give you the documents? Who will give you the proofs? The client itself, or the litigant, or the agreed person. Now, date helps you to put it in a ascending order. That 1971, this event happened. Let's just assume this was a case where auto scrapping policy and everything was to be done. So that person had scrapped his vehicle, three-wheeler in Delhi and all. So first policy came in 1998, but he had purchased the auto, that's an automobile, in 1979. So how will you prove that? Either by some invoice, either by some registration card, either by some document of purchase, isn't so? So over here, it was a loan which was given by the bank. So that loan document, my statement was in 17/12/1971, this auto was purchased. So I made a specific table so that I do not skip any fact. Relevant, irrelevant, I'll take later on. But when I'm narrating, when I'm collecting those facts, I can do like this. Date, then I give a brief gist about the event. Now, what will happen by this is when you put it in a very tabular form, when you reach till the last fact over here, like every date has been mentioned, it's in ascending. When we reach at the last, we have a short kind of summary before even we started drafting. Now, this is cross-referenced. Cross-referencing is also now very important. Date, event, the document which is referred. Because tomorrow when I'll file this case, I'll make my pleadings. I'll say that this happened. Other side will definitely come up with this defense that you are saying this. What is the proof to that? Whatever you have stated, what is the proof for that? Either it's primary, either it is secondary. Okay. Now, if there's a document, make that document a short annexure. That P1. P1 is the document from here. So now, when you make all these kind of tabular representations, this will help you when you will go for the first date of hearing. Your pleading might be in voluminous pages. For example, hundreds of pages are there. But when you are before the honorable courts, you can easily and quickly take this case note. You can easily scroll through them. They have been cross-referenced. If court asks you that, okay, how you come or how are you having a locus over here? So I have a locus because I purchased a vehicle that was in 1979. I can quickly refer to that document. That document is already annexed as P1. So what does it do? It saves judicial time and it makes a good image and a rapport of the person who is arguing, the counsel who is arguing, that this person is not wasting any judicial time. So he is very serious about his case. And moreover, whenever you must have seen court proceedings, how much time do you get to argue? At the stage of first issuance of notice, hardly 4 5 minutes. If you can make out your case in those 4 5 minutes, if you can come up to the gist, if you can navigate through your pleadings easily, then only the other side is concerned or shows any concern in hearing you. Otherwise, what happens? Voluminous pleading. I'm not getting any point of this. Why should I keep it? Keep it for some other day. So it deviates. So first thing is collection of facts. We'll end up by this. Collection of facts is only facts. Ask your client maximum facts, whatever he wants to say. Relevant, irrelevant, that is not to be done by him. That is to be done by you. Facts have been collected. What else now is required? Documents to prove that, testimonies to prove, witnesses, if any, those who can give witness in your favor. Make note of that also. Now these are collection of facts. Merely collection of fact will not help you. What else is required? Law. What does law say as on date? Okay. Now, I'll tell you one thing. All of you must have followed the recent judgments or following the recent judgments that are coming nowadays pertaining to bail. Let's just put it like this. Bail, there's a new recent judgment which says if you're filing a bail, you have to file along with that bail all the arguments, all the defenses which you have raised prior to this bail application, which have been dismissed, so that the previous past conduct and past involvement of that person, of that applicant, is revealed. Earlier, this was not. Earlier, everybody used to say, harm to him, he does not have any role, such and such and such, and number of bails filed. But now, if you're filing the bail, you have to give the past all defenses which you have raised. Okay? So, law, changes in law, notifications, what is the new amendments, you have to keep them in mind. Any doubt, any query till now?
No, sir, no query.
Second thing comes is, once we have collected our facts, we have all the synchronized facts in line. We know the law. I think some people are having gala time in this. Coordinator is there? Anybody from Team LeDroit?
Yes, sir. So just give me a minute looking into it. So you must have received a request to unmute yourself.
Okay, I just got it.
Yeah.
Now,
So
second thing is, sorry.
so now just I made the changes. Now others can directly put their queries on the chat box, and only the faculty can speak. Okay. So in order to not have any disturbance during the
No
session.
issues, no issues.
Yeah.
So, as we said, fact and law. Now they will work together in your drafting. If it was only narration of facts, everyone could have done it. The litigants would have done themselves. But why do they use? Why do they come to you? Why do they want your assistance? The only thing is now you can put those facts very well decorated with the law. Now, once you have all the facts, now you go with the law. For example, a person comes to you and says that I have a ancestral property. Uh, I'll just take these questions. Just let me finish over here. Now, the issue is there is a will. How many? Everybody knows about will. Now, when there's a will, can you simpliciter, if you are a beneficiary to that will, can you simpliciter derive the benefit of that will? Then comes the concept of probate. See, drafting led a losing or case of a win. There are category of judgments which say that ignorance of law is no ignorance. You cannot say that when I drafted it or when my counsel drafted it, they could not mention this point. It has to be conclusive, it has to be complete. Because of the reason that once draft has been finalized, it has been placed on record, it becomes final. Now, in the very rarest of the rare states, it can be changed. And it's an discretion of the court. So, that time it becomes very difficult. In civil procedure, you might have seen that if you want to amend a plaint, it should not change the defense of it should not change the nature of your case. So that is why everything has to be done at a very initial stage with proper thought. Nothing should remain unattended. That's the most important and integral part of your drafting. When you have collected, second thing comes associated laws. What the law as on date are connected to this? Let's just put it like this. Agreement to sell has been executed between A and B pertaining to a sale of land that is going to be done after 3 months. Now what happens is A refuses to sell this land to B. Which law will be here? Specifically, not Transfer Property Act. Transfer Property Act talks about ownership. Yes, Indian Contract Act, Specific Relief Act. That now, if you have executed an agreement and now it has been breached, either you can seek damages or as per Specific Relief Act, you can seek directions that this person, the party privity of the contractor says this, the person who has executed a contract has to fulfill all the or has to perform his duties as per the contract agreement which he has undertaken. So if you don't know about that particular law, even though you have drafted well all your facts, it will be of no use. Then one concise relief should be sought. So whatever facts you have narrated, there are ample of things which are now claimed that damage occurred, pain and agony, this is compensation. But what will satisfy? One simple relief. So now, concisely, that relief is to be seen. What you are going to seek from the court. It cannot be either give me this land, either give me the money, either interest at this part, or either this. It has to be one simple relief to satisfy all the disputes. Because it should be a prayer, single prayer or one or two prayers, everything should come to an end. Otherwise, it will be a never ending thing. That today you will seek this, that possession of this property, then you will say, no, possession was there, but now I seek compensation also. Now I have sought the compensation, now I seek quantitative damages also. So this is going to be never ending. So it says it has to come to a conclusive end. So now it says facts presented in a synchronized manner, synthesized with law. Thereafter, when you have done everything, the next thing is how to explain what is the injury that has been faced. And that injury is called as cause of action. Cause of action, everybody is aware about that what led to coming to this particular court or this judicial authority or tribunal. If you do not have a valid cause of action, you might have drafted everything, you might have given law, but there is no such cause of action which gives rise to any dispute today. Then nothing can move further because it says without cause of action, it is to be dismissed in thereon on the threshold. Cause of action you have to start for some other reasons also. One is your limitation. In criminal side, there is no foundation timeline, there is no limitation. But in civil side, we specifically follow Limitation Act. Let's just say a cause of action comes today. So from today's cause of action, next 3 years, you are there to file a civil suit. So you have to keep that also in mind. See, if there comes any evaluation of property and other things at the later stage, at the time of final arguments, you can file an application.
So your voice is breaking.
Section 151 court. I'm audible now because I think internet connection is stable over here at my end also.
Now you're audible. Yes.
So next thing which comes is, just give me 1 minute. Now, subject matter we have discussed. Now example to that subject matter. Okay, we were discussing example of will. Okay, how many of you are aware that will can be executed, and even though it is not registered, it is still having validity? If a will is not registered, it still has validity. Any reason for this? Any reason for this? That will has, even though it is not registered, it still holds validity. Will is a person's last wish. Take it. Now, all of you must have known or even heard from some persons that whenever a soldier goes on the war front, they are made to write letters to their family. Why are they writing those letters? Those letters are that if there's any asset, if there's anything they want to share it with the family, they can do whatever needful is to be done. And those letters are treated as will. If registration is made mandatory, then the essence of this particular document is lost. Isn't so? So that is why wills, even though if not registered, they hold some validity. Just give me one.
So you're not audible. Guys, I think sir has taken a minute to fix the network issue, okay? So let's just wait for 1 minute.
Am I audible now?
Yes, sir, you're audible.
Audible? Because
Yes.
there was some issue at this end.
So
Okay.
still the voice is
Now
breaking, so maybe you can switch the camera off, then it
I'll
will be
do
clear.
I'll do that. I'll do that. Just give me 1 minute. I think the quality of internet is going. Now, so it says synthesis of law and fact. It has to be done. If you cannot argumentate, if you cannot divert your facts to produce what difficulty, what breach, what cause of action, or what injury you are facing, can you just put any relief to your client? No. So you have to establish the legal injury. First is facts, second is law, third is establishing the legal injury. That what legal injury your client or that litigant is facing. Till now, I have not said that you have to give any case laws, any references. Did I say so? No. People have this assumption that whenever we are drafting, we have to draft in terms where we use precedents. Okay? And those using of precedents will enhance our drafting. That is a wrong notion because every case is different. Precedents are only taken when precedents are only produced when we are going to argue, when we are going to interpret, when we are going to substantiate what we are saying in terms of what has already been settled law as a good law by the precedents. But in drafting, it says only to state and not to argue. You have to state your facts. That's all. You have to state your facts, identify the documents which you are relying upon, identify the evidences which you are relying upon, state what, as per the facts of the case, say and how they are synthesized in law. For example, father has a self acquired property. He passes away. His sons are there. There are four sons. What does law say? Law says if there is any property, self acquired property, father dies without any will, intestate, all the legal heirs, all those sons will have equal share, one fourth. In terms of one fourth share, any of those sons can file a partition suit or can initiate a partition of that property. So this is law. And others will not disturb his case by saying that we don't want to. He has his legitimate share. So pleading means only statement of facts, not law. You need not to argue over there. Just state your facts. These are the facts. This is what law says. As on the date, in these facts, this particular thing happened because of which legal injury has occurred, or there is a fundamental right of my client or that litigant which he or she wants today. Law as on date supports in these facts because law states that yes, he is eligible for one fourth share in this being a legal hire, class 1 legal hire to this person. Okay. Another aspect of not using precedents in your initial drafts is whenever you draft your cases, if there is any good law in your favor, will you open up that good law in very initial stage to the other party so that they come up with all the probable defense cracking on you? You will keep those ace cards that whenever we'll be arguing at the final stage, we'll come with this. Okay. Now, these are all when you will start drafting. But before you start, how you can excel in your work. Now, as a newcomer in this field, I also face the same thing. That I also thought that whenever I'll be drafting from my own. I'll start whatever facts will be given. I'll do whatever things to be done in my best of knowledge. But what happened? There is a specific language of court, isn't so? For example, court uses certain maxims. Court understands certain legal words, legal dictionary. Okay? That only a lawyer can understand, and it's better between communication between law judge and the counsels. So when these kind of things are there, I was sharing my screen, but I think there's some issue over here. I'll try. Is it visible now? I think it's visible now. Now, for that, before even you start any draft, see, I cannot say that you write in this way, you follow this grammar, and this will be done. No, there's no such linear equation. Every person has a different style of drafting. Some might be drafting in a Oxford dictionary language. Others might be drafting in a very basic plain language which can be understood by any person. Any well-read person can understand that. Others use maxims. So every person has a different style of drafting. Some follow a summary kind of a draft, that they just come quickly, short and crisp. They don't go here and there. Some follow giving a background of the case. So it's depending upon the case and how, what style of drafting you follow. But for better drafting, there are certain things which you can do. Follow one judgment from your area of interest. If you have any, let somebody in the initial said bail, bail in rape cases. If this is your area of interest, start following criminal court judgments. Everybody is, nowadays, these judgments are open to public. They are all on public domain. If you just visit the Honorable Supreme Court site, you can easily follow these judgments. If you go over this,
Sir, can you please repeat the name of the site you mentioned?
sorry,
I think so. You mentioned a name of the site. Can you please repeat the same?
I said follow one judgment from whatever area of interest you follow. For example, somebody said criminal side bail. If you're following bail, if you're following criminal side litigation, you can just go to the Supreme Court's website, because nowadays all these judgments, all these leading judgments which are passed by the Honorable Supreme Court, they are all available. Just click over here. Either you can type the name, judgment date, whatever you want to see, or there are certain judgments which are reportable and they come on the, just give me 1 minute, over here. Oh, visible? Like this is a civil appeal. If you are interested in civil matters, civil side litigation, follow this. This is criminal appeal.
Uh,
Open this judgment, go read it. These are all reportable. They are all
so
available easily.
sorry to interrupt, sir. If you are sharing some other screen, it's not visible. Like the exercise screen is visible to us, not
Okay,
any.
okay, 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 okay. Just give. I'll just do one thing. I'll share all. Visible now? Just go to the Supreme Court, Honorable Supreme Court's website. Everybody can access it. Now, go to the judgment clause. There are judgments which are passed daily. You can just go through these judgments. For example, it's a criminal appeal. Open that judgment. Very well, easily written, 16 pages. Just don't try to understand, just read them. Now, what is this? Special leave appeal passed in such and such, whereby appellate preferred respondent number 2 is accused under section 14A of SCSC Act. So now this case pertains to SCSC Act complaint. And she was granted bail in connection with this, in this case, registered for the offense of 341 and other things. So now, this is the case. You can just go through facts. You can just go through what are the defenses they have led, what are the allegations, averments they have led, and at the end, you can just go through the observation of the honorable court over here. For example, recently this court has placed reliance upon cancel the bail granted to the accused in the case of dowry death. So now they're giving you the other cases also. By this, what will happen is, one, you will go with the legal vocabulary. You will understand the legal vocabulary better. Second, you will come through across all the good laws which are not repealed yet. For example, if this case is cited over here, that means it's still holding good. Okay? Otherwise, it would have been repealed. Okay? Now, you get all these. Whenever you have a specific observation by the honorable courts, that means they have checked this and then only this has been mentioned in this case. So for all other cases wherein you will see a dowry death case, bail is to be cancelled. Now from here onwards, you can just keep this citation for your future. It's not only applicable over here. You can note this citation. Later on, you can use it in your final arguments, or you can take the observation parts. You can just write in this is a catena of judgments. It has been held. We are filing this cancellation of bail in case of dowry death. And however, in such cases, Honorable Supreme Court in catena of judgments has also relied upon, wherein they have tried to paraphrase this in your own words. It will add on to your pleadings. Okay. So first thing is going through your judgments. And I'll just suggest you one thing. Better is follow your respective high courts and the Honorable Supreme Courts, because these are all final verdicts. Any doubt till now? Now, facts, how to be written. When you read these judgments, you will see that the author of these judgments, they narrate those facts in a very simple and a very precise manner. And by the mere reading, you understand what are the cases, what are the defenses taken in this case. Case is, let's just assume A says A is a complainant. He has filed a complaint for 138 NI that the check has bounced. Because of that, he has the case facts are A met with B. They had some business transactions. B got his work done from A. In return, to pay him, he made a check payment. He gave a check to him. That check got dishonored, and for that dishonor, there was a specific reason, that is insufficient funds. Now, when there is sufficiently written insufficient funds, that means when the check was issued, Mr. B completely knew in well advance that this check will not be honored. That means Section 138 offense has been made. Now, what is the defense of Mr. B? They will come with that. That Mr. B says it was a security check, and this work which Mr. A had given done, that was not up to the mark. That was a disputed thing. That's why this payment was stopped. So these are facts. Then they will come up that what is the issue. Issue is whether the offense of 138 is made or not. Then they will come with the evidences made. So by that way, you will understand how the facts are to be placed. There, they will interpret law. What is the presumption of 139? Who has the burden of proof to be done? If a check has been issued and that has been dishonored, prima facie case is made out. Okay. Maintaining and drafting of notebook is very important at your initial stage. Whenever you go through these judgments, there are certain cases which are leading case laws. If you come through them and you have seen that this case law is very often utilized or reproduced in other judgments also, make a note of that. Okay. Uh, anyone over here, does anyone know about the case which laid down the foundation that an FIR is to be registered whenever a offense is narrated, cognizable offense is narrated to a police? Which was that case law? Achha, you all know that there was a case which laid down that even if a simple complaint is made which discloses offense of cognizable offense, police has to register an FIR. Investigation done or not done, that's secondary, but registration of an FIR is to be done. They cannot deny registration of FIR. There was this judgment of Lalita Kumari versus State of Haryana. So when you go through these judgments, this thing will upgrade your knowledge. Next is judgments might be difficult for some. So if there's some difficulty in reading those judgments, just try to observe new words. Don't try to understand. Just try to grasp new words. If you're reading articles, read some good newspapers. But don't use the language of newspapers, because newspapers, they have different kind of languages. For example, for some high officials, there might be specific definitions, that daroga and all such kind of language. You should not use them in your drafts. So you can just take the articles. You can use how they articulate the words, how they use them, how they frame phrases, how they end the sentences, how they move with the narrations. The best thereafter is if you're in some chambers, if you're doing your interns, because now you will be joining as an initial phase. All of you who are now new in this field as a student, you all will be doing your internships. The best thing is learn from your seniors. Wherever you are joining, try to read those pleadings. If there's any file assigned to you, if they are saying just go with this file and just mention it in the court and just take password that I am coming, before that, even if the file has been given to you, try to read it. When you will be reading those case files, you will yourself understand how a systematic chronology, how words have been placed, how statements are made, how annexures are placed, how evidences are led. And you can also follow the writing style of your senior, whomsoever you're following over there. For example, some use the uh, theory of giving a systematic list of date and events. As I just showed you, that I prefer this. Before even starting my draft, I prefer this. That list of date and events, I prefer that it should be first and foremost mentioned in your draft. Why? Because when the file, when this document, when this plaint is produced before any person, he can easily grasp whatever I am saying. Otherwise, it will be difficult for that person also to attain what I finally want to say. What is my case? So, for better understanding, I brief it out. Others might put some bullet points that this is the summary of my case. So, in that way, grammar and everything, that is, everybody knows. I should not emphasize on that, because we all know where to use punctuations, where to end the sentences, where to keep those sentences short and small, because law is all about interpretation. Where to use shall and will. What is the difference between shall and will in legal terms? Shall means mandatory, will means might be. So if there is any whereat you are reading, if it says that person shall, that means it's a mandatory provision. Okay? Or court shall, that means court has to put it in mandatory thing, whatever law has been. So we have to deal with those things. Now, when you are going through your regular drafts, you will be dealing with your clients, you will be dealing with the documents, you will be dealing with the interpretations, because now clients gave you facts. Once facts given, you will put them in conscience with your drafts, and in that time you will also take all those annexures, whatever documents they might have given to you. But now synchronizing them with law is your skill. If you fail in synchronizing that, whatever you might have drafted will be of no good use. So I've just taken a summarized manner that first stage drafting is all about preparation for draft. You get your facts, collect your facts in a systematic manner, as we just mentioned in that tabular form. Collect all those documents, take all those instructions from your client. This way you will make a case note. Don't start drafting. Have a full knowledge about your case. Try to figure out what is the legal injury, what is the main grievance. Let's just assume main grievance is that a person has done a work contract was executed, but that money has not been paid to him. So main grievance is recovery of money. Okay. Now, client's problem is not only recovery of money. He says no, recovery of money along with my compensation, because now interest part is also involved. For this, I have taken money on credit. So it's not simpliciter that I should be paid principal amount. I have taken money on credit. So legal injury along with client's problem. Now, why he is with you? He is with you to get a solution. Now, what is your solution? You will first address him that, okay, this is your legal injury. Facts I have seen. Documents, there are work contracts, there are deliverables. You have given those services, you have raised invoices, they have acknowledged those invoices. So everything is admitted. But solution is you now put a legal notice to them. Once they will get this legal notice, if they still hold your money, then you will file a civil recovery suit, or you can file a criminal complaint that they have made you work, and from day one they were in this knowledge that they will cheat you. So this is a criminal offense. So you can give them this legal solution. Once you have given this legal solution, you have to establish the foundation. What is your foundation? Foundation is, you will narrate the case. Now you have to establish that this legal injury has occurred because of breach of other person, from where, against whom you are filing this case. So this is your foundation. Because now when you have laid down this foundation, everything will work on this foundation itself. If you fail to acknowledge, if you fail to establish any legal injury, if you fail to acknowledge, or if you fail to produce before the court that this particular debt was acknowledged, or this particular invoice was acknowledged by that person, yet he has not given money back, you will have the most credential part of your pleadings incomplete. That is cause of action. If that goes, whole of the case goes. Then we have not started. Try to figure out paramateria cases. It's not the see, cases might be different on some aspects, but main universal fact remains. For example, court has given a judgment which is a now a established law for recovery of money or recovery of debts. In terms, there is a contract, commercial contract. So it says there is a commercial court act. There are judgments wherein it says if the debt is admitted, we can go with the summary trial. So try to figure out those case clauses. Try to see what legislation says. Is there any precedent which has recently been done in such cases? Which law is applicable? Are there any notifications by which law has changed, or for that time period the law has been suspended? When you give a combined reading to whatever is this, now you go on the second stage. Now second stage is first rough draft. Try to write your drafts by hand. Now I know everybody is well equipped with typing skills and all those electronic devices, but initially you should, if you are drafting a legal notice, try to write it. If you are trying some formal email communication or some compliance email to your client, write it first by your hand. Why? Because that will help you grasp those facts, and there is a coordination between your mind and hand. When the coordination works, it retains in your mind for longer time. Never try to give facts in a loose manner. For example, if you have started some narration that A met B on such date, that's all. Why you stated this fact? What exactly you want to make point of this? A met B on this date, and on this date they executed a board resolution wherein the points of this particular task which will be going to be dealt were recorded and signed by both the parties. This means you have completed, you have closed that event has been closed. When you started that narration, you brought it to an end. It is not open-ended. Open-ended facts lead to nowhere. Once your rough draft is ready, try to read it again. That is known as proofreading. When you are able to understand from your own writing skills, that means if you are satisfied that yes, it while reading it, there is no hindrance, there is no stoppage, there is no break in between. That means this is a good draft. When you try to read it and you acknowledge that whatever you have stated is understood by you very simple way, that means it will be understood same manner by the other party also. Take care. Maintain a sequence. Never go haphazard. Maintain a sequence, give references, because if your draft is well referenced, it is easy to understand. If your draft is not referenced, for example, you say annexure A, there is no page number, nothing over here. You have not mentioned what is annexure A. Who will read it? Nobody. So these are very small things that need to be considered. And after proofreading, give it a final touch by approaching your senior, at least for first initial phase. Try to take their inputs also. There is no harm. There's no harm if they point out some correction in your draft, because we all learn from our mistakes. This is how it will be used. Now you can put your questions so that we can just deal with them. You can just open your mics if you.
So actually, you can only unmute yourself now. We
Okay, no
had
issues.
restricted, so yeah.
See, using negative terms, I'll tell you one practical example to this, and that will answer your query. If I'm using authoritative language, I'm not saying negative. If I'm using authoritative language in my plaint, whom I referring this plaint to? I'm referring it to the honorable chair. So there's some discipline, there is some decency to be maintained. Can I use that language if I'm asking for some remedy or if I'm seeking some relief from there? No. That means my language that time will change to from authoritative to submissive, to submissions. Not submissive, because I'll not be that timid in my language. I'll put it in a very better, polite manner. But if I'm writing the same thing in my legal notice, I can be authoritative. So I have to see which draft is going to be read by whom. So we have to read the person to whom we are referring to. For example, if we are giving a claim to the honorable court, if we are filing it before a honorable court, can we put in a summary manner? No, because court needs to understand, court needs to know all the minute details. But if we are filing a complaint before the police station, do we need to go extensive? No, we have to just come up with the basics that this is the case, because now that person is already burdened with multiple tasks. He wants to know why you are here. He does not want to decide it. He is not going to decide it, but he wants to know why you are here, what help he can do. So if you burden him with 10, 20 pages, he'll not be able to work. He'll not be able to give you any fruitful results. But difference comes when you go before the honorable court. You file a complaint before the magistrate. You cannot go with a simple summary kind of a complaint. You have to give all those details. You have to give all those evidences. So drafting is somehow connected to also interpreting to whom we are referring to. It cannot be said that the same line of argument, the same style of drafting which we are drafting in court will also apply to other quasi judicial bodies also. So likewise, that's why we refrain from using negative terms. Even if we have to say somebody is a thief, we will not say directly. We will say he has siphoned off some money. He has committed some embezzlement. We will not say directly. There's some decorum which is to be maintained. And drafting is whatever you cannot say, you can articulate in your words and put it in your records.
Um, Thank you, sir. So, sir, I believe we have already extended the time. So, if we can wind up now.
No issues. I'll hand over the session to you now. Over to you. Thank you all.
Thank you so much, sir. Can we please appreciate sir for sharing his knowledge with us? I'm sure the session was highly helpful for you all. Can we please have claps, please, for the sir? I'm sure you guys learned new things. So I'm very sure, sir, they enjoyed the session. They loved it. They learned new things during the session, like how to refer to case laws, how to read judgments, and what are the things to consider before starting with legal drafting. So thank you so much for your valuable time and sharing your insights with us. Okay, those who are asking whether you can get the PDF or not, I'm sorry, we are not going to share the PDF, but for sure we are going to provide you with the recording of this session. Please don't leave the session because we haven't shared the feedback form yet. Okay, so kindly stay on the call till then. Okay, all right. So just give me a minute. All right. So before sharing the feedback form, I'll be I'll be sharing the details of the course because some of you have joined the session as a demo session, okay? So just give me 5 minutes. I'll be taking you through, like, if you want to learn more about drafting, you can learn about the courses as well, which are starting from 28th July. It will be conducted by Sir only, and they are at a very much affordable price range. So just give me 5 minutes and I'll take you through the details of the course. There will be three courses which I'll be explaining you, and then we'll be sharing the feedback form. Okay, so just give me some time for the same. Let me just know once the screen is visible to you. Also, if you really love the session, tomorrow as well, we have one session on contract drafting and common mistakes made during contract drafting. So you can join that webinar as well. The link for that has been shared in our LeDroit's WhatsApp group. So from there, you can join the group. Okay. All right. So now, yes, that webinar is also free. That webinar is free of cost. Okay. Tomorrow it will be conducted at 5 p.m. Okay. So now just 1 second. Okay. 1 second. Okay, sure. So now I'll be sharing the details of the course. I hope my screen is visible to you all. Can I have your thumbs up that the screen is visible? Please don't leave the call. I'll be sharing the feedback form just after taking you through the details of the course. Okay, stay on the call. All right. So we have the course on legal drafting. This course is starting from 28th July. Okay. It's a 10-day course, live course where you can interact with faculty and ask all your queries. In the course, you'll be learning about how to draft legal notices. Four type of legal notices will be explained to you, like how to start with legal notice, how to draft section 138 notice, divorce notice, and employer settlement of claims notice. Okay. And how to also reply to legal notice. These will be covered along with what is an affidavit, what is complaint, how to draft a complaint, how to draft an affidavit, overall civil suits proceeding, how to draft a civil plaint, drafting of a non-joiner and misjoiner of parties, written statement. All these things will be covered in this particular course. The duration of the course is 10 days and the timings will be 7:30 to 8:30 p.m. The classes will be conducted on Google Meets. Okay. You'll also be provided with the recordings of the session as well as reading materials as well as sample drafts. And you'll be having access to the recordings throughout. Like even after the course, you'll be having access to the recordings. For this, you'll also be receiving e-certificate. Okay. Once the course is over, you'll be receiving e-certificate for the same. The course is currently under offer price. The fee for the course is just rupees 1500. Actual fee is 2000, but currently it is available under offer price of 1500, and this offer is there till tomorrow. So if you want, you can go for this course. If you are much more interested in learning about, much more things related to drafting, so first thing I would like to clear that all LeDroit courses cover everything from basics. So whatever you'll be learning, even if you're in currently first year, you can do this course because we'll be covering everything from basics. And towards the end of each course, each LeDroit courses, we have practical assignments where faculty personally review your assignment and give you feedback on your performance. So you will be given two practical assignments based on practical situations on which you have to draft, and you'll be receiving feedback on your performance, personalized feedback. Okay, so the last session of the courses are always a feedback session where you get a personalized feedback on your performance. So this was one course. Now, if you are someone who is much more interested in learning more, then we have an advanced course on legal drafting. The reason it is known as advanced is that it covers more topics. Okay. The duration for this course is 2 months. And under this, you'll be learning all the topics which I mentioned earlier, all the legal notice, affidavit, civil suit, all the things. Plus, you'll also be learning about real estate agreement, RERA, how to do title search of property. All that will be covered. Plus, you'll also be learning bail applications, bail bonds, and also you'll be learning writ petitions. Okay, so that is also covered in the course. The overall duration of this course is 2 months, and the difference in this is that you'll be receiving access to all the reading materials, sample drafts, recordings. Plus, you'll also be getting hard copy reading materials and certificate. So towards the end of the course, you will be receiving the certificate as well as the reading materials delivered at your place. Okay, this is also a live course. Timings will be same, 7:30 to 8:30 p.m, starting from the same date, 28th July. And in this, the price for this course is also under offer price of 4,500 only. And in this, you'll be getting hard copy reading materials plus certificates. So the actual price of this is around 5,500, but currently it's available at your offer price of 4,500. Okay. If you don't have any questions, I'll just move on to the third course. If you are someone who is interested in corporate plus litigation, then you can go for this combo that will be highly helpful for you. There's a combo of ultimate drafting combo. Okay, in this you are getting four courses. That is legal drafting, which we covered, plus contract drafting course. Under that you'll be learning business agreements and all. Then we have a software contract drafting course, and then we have your real estate agreement drafting course. So contract drafting and software contract drafting covers corporate drafting, like agreements used in IT industry, NDA, MSA, service agreements, how corporate sector works. Plus, you'll also be learning litigation stuff, like all the legal notices, affidavit, plus real estate sector. So these things are highly demanded right now. Drafting is the core skill that you should know as a lawyer in order to create your career, be it in litigation, be it in corporate. It's the core skill. Okay, and this course actually provides you a very budgetable deal, because the price for each course is around 1,500 to 2,000. But in the combo is still today. This combo is there till today. In the combo, you're getting all the four courses at just rupees 4,000, and you'll be receiving separate certificates for each course, and the reading materials and everything you'll be receiving separately. Okay, for each course. So if you have any further detail, you can reach out to the group admins, and we'll share more details about the course. We'll be sharing the links of each course in the group as well. You can go through that, or you can directly visit the website of LeDroit. Okay. All right. So yeah, now I'll be just coming on to the main topic that you guys need the feedback form. So I'll be sharing that. If you guys have any doubt with regard to the course, let me know. Also, like, if you are interested in learning more, you can subscribe to our YouTube channel. Over there we go live every Friday at 6 p.m. Okay, so you can attend, like, learn about new topics from there. Let me just know once the feedback link is available to you, if you can access the same. Okay, just confirm on the same. Everyone can access the link. Yeah, so for your certificates, we'll be updating in the group. We'll take around 1 week's time to share your certificate. So once it is shared, we will update in the group itself. So please don't leave the WhatsApp group of the webinar. Okay, and make sure that you fill this form up and then leave the session. That's all for today. Hope you all enjoyed the session. Stay connected on LeDroit WhatsApp group and YouTube channel to learn more such insightful things. Okay, hoping to see you all in next session, and as well as in the course if you really interested in learning more about drafting. Thank you everyone for your time. Have a good evening ahead. I've shared the feedback form, just resharing it again over here. Please go through the same.